We want to instruct the jury about attorney Harry Smith's testimony that he warned Stacy Peterson she could be charged with concealing a homicide. This goes to correct a misstatement of the law that Mr. Smith gave from the stand.
I will say that when Mr. Smith made this statement in front of the jury about concealing a homicidal death at the time, you did not cross-examine him any further when he made the statement. Is that correct?
I only cross-examined him on his prior statements that it was extortion.
So you had an opportunity to cross-examine him on whether the information he was giving the jury was incorrect?
I was a bit taken by surprise.
How does the fact that you were surprised and did not cross-examine him on this issue, how does a jury instruction cure that?
Because it would advise the jurors that the law he told them was wrong. They could use that in evaluating the weight and credibility to give his testimony.
I believe everybody will believe that what she told him did not constitute the crime of concealing a homicidal death. That's a separate issue from whether or not a special instruction is curative. If you abandoned that line of questioning, I don't know if you can come back and ask for a jury instruction later.
The fact is that he was wrong, and it is the court's obligation to advise the jury on the law, not a witness obligation. It would be unjust to have the jury have an incorrect understanding of the law simply because maybe something should have been said or done earlier.
You called him. You called this witness. There's nothing I can see that the state did to augment or embellish Mr. Smith's testimony. The defendant's proposed instruction is denied. There was no request for a sidebar, no request that the court correct the information. So the relief the defendant seeks in the form of a jury instruction is denied.